One of the misconception that some people have in doing estate planning is, I've set up my living trust, have a will, have some powers of attorney for my financial affairs and for health care, and therefore I'm all set. I don't need to worry about it anymore. But circumstances change, laws change, and so it's good to review those documents, have them reviewed periodically. You get married, you get divorced, you receive an inheritance yourself, and you want to leave it behind in a particular way. People that you've appointed as fiduciaries or people to make decisions for you have passed away, or they've moved away, you've lost contact with them. All those things can be a good reason to take a look and review your plan and make sure that it's still expresses your desires correctly. It's not, in that it's best to come and talk to an attorney to make those updates, so that way you can make them correctly and make it according to how your desires are. So that way you don't change one thing and negatively affect some of the others. One of the key issues that's happened in the last 10 years is a change on the estate tax, and there's been a significant increase, as well as an ability to save your spouse's exemption. But you don't need to worry about too much of the technical details, but it makes it so all the estate plans and the living trusts that were drafted in the 1990s, early 2000s, that oftentimes they were done in a way where after the first spouse that passes away, it splits into what's called an A trust and a B trust. And the way that the laws have changed, to take full advantage of the savings on the estate tax, you don't necessarily need to split the trust into two anymore. And so if you've created a trust, back in the early 90s and 2000s and haven't looked at it before, it's a good thing to have an attorney look at it and see if it's something that you'd want to change, and that change could, if you want it could be something that could provide additional efficiencies after something happens to one of the spouses.